So good morning, everybody. Thank you for coming and attending our webinar this morning on CCPA. This is something that we have done every year. Thank you to Chris Hart and Colin Zick from Foley Hoag, who have really been instrumental in helping us keep apprised of regulations. I'm sure they will talk about GDPR and other regulatory laws throughout the US and Europe, and keep us going on this. But before we get started with them, some quick housekeeping. One, this program is being recorded. Second, I am going to keep everybody on mute for about the first 45 minutes as Chris and Colin go through the regulations and where we are on updates for statutes and how it's working both interstate and globally. If you have questions, please either use the questions or the chat function in your dashboard. We will take those throughout so that we can clarify anything that you need. And then at about the 45-minute mark, if you have a question, I will be unmuting people. You can either use the hand raise function or put it in chat, and I'll just go ahead and unmute you. I want to very quickly thank Deloitte. They're our security community sponsor. Without their support, we wouldn't also be able to do these types of programs. And a thank you to the Mass TLC Global sponsors. Without their support, we would not be able to do any of the programs that we do throughout the year. So thank you very much. Now I am going to turn it over to Chris. Just a moment.
All right, good morning, everyone. I'm Colin Zick, and with me is my partner, Chris Hart, and we're pleased to have you all here on this webinar this morning to talk about CCPA. It's been, as Sarah said, about a year since we were talking to folks, and while a year ago, I think CCPA took a different relative priority in our framework, a lot of other things are now priorities. It's still something that we've got to pay attention to, and in perhaps some new and different ways. And so it's a good time to talk about that, as we're hopefully also looking at a time where we're coming out of lockdown. Again, it's a time where we start to think about other things other than COVID-19, but we'll talk about where COVID-19 has a role to play here too. So a little bit about myself. For those of you who haven't seen me on one of these before, I'm the co-chair of our privacy and data security practice. I also co-chair our COVID-19 task force. So I've been working with lots of folks in preparing our responses to everything and anything that has come down in the last 6 weeks or so, and there's been a lot of that. And we'll try to talk a little bit later about how that interacts with CCPA and other things. And as I said, with me also is Chris Hart, and I'll let him introduce himself.
Good morning, everyone. I'm very happy to be here with Colin and Sarah and talking about CCPA, COVID-19, and other updates to privacy laws. I'm a partner at Foley Hoag's litigation department and co-chair the privacy and data security practice along with Colin. In addition to that, I co-chair our blockchain and cryptocurrency group. And have been involved over the past 6 or 7 weeks. I've lost track of time at this point also in assisting clients both in responding to the current crisis as well as just thinking about their ordinary compliance work. So I hope you get a lot out of this webinar. So I will get started by just setting the table on the California Consumer Privacy Act. I'm sure many of you are already familiar with it. Maybe you've already done a lot of the work of compliance to the extent, or at least deciding whether or not you need to comply. Let me just give a little bit of background here. So the California Consumer Privacy Act provides a number of, at least in the US, new and unique rights. And in fact, the entire framework of the CCPA is fairly unique in US law. It has a lot more in common with the GDPR than it does with a lot of US law, and we can talk a little bit about differences and similarities with GDPR, but among those is this concept of consumer rights. You know, a lot of US privacy law is really about consumer interests vis-a-vis business interests. And often that balance of interests falls in favor of businesses. So what you'll see in a lot of state data privacy laws, they're mostly breach notification laws with some exceptions. And what you'll see in those laws is that if there is some harm that affects an individual whose personal information was, and by the way, I apologize if you hear any loud noises in the background, it's because I have a 2-year-old in the background, so I apologize for that. Often the breach that's involved in a breach notification statute is about a name plus some other information, like a social security number or a credit card number or something like that. The CCPA thinks about, well, California law is a breach notification law. The CCPA thinks about privacy rights much more broadly, and gives individuals, California residents, specific rights. So those rights are outlined in the slide. One is the right to opt out of sale of personal information. Sale has a distinct definition. The right to delete information, which in the EU is called the right to be forgotten, but it's the same concept. You can request to have your information deleted, your personal information deleted. The right to know, the right to request information about what personal information an organization has of you. And then there are anti-discrimination rights. So if you exercise any of these rights, you can't be discriminated against by the organization to which you are requesting that they exercise or that they respect your rights. These rights are qualified. They're not absolute. So, for example, the right to delete has a number of exceptions. From my perspective, they can be so broad that you can drive a truck through them. But the important concept here is that these rights are given to consumers. It's very unique in US law. They're not absolute. And so organizations have to think about how they're going to comply with being able to provide these rights to consumers, and also think about when do the exceptions apply and how to apply them. The CCPA went into effect January of this year. So if the CCPA applies to you, you have to be in compliance now. The enforcement date isn't until July 1st. And the enforcement is through the California Attorney General's office. The AG will have discretion to look back. So even though July 1st is the enforcement date, the AG will have discretion to see whether or not you were in compliance for the past 6 months. So it is important to be in compliance. And Colin will talk a little about this, but every indication from the AG's office has been there's not going to be a pass for the current pandemic. You're still going to be expected to be in compliance. What that means in practice, nobody really knows. Not even sure the California AG knows. The CCPA doesn't apply to any organization that does business in California. First, it applies only to for-profit companies. So if you're a nonprofit, it's not going to apply to you. And then you have to meet one of 3 criteria. Either you have revenues of over $25 million, you are collecting the personal information of 50,000 or more California residents, or more than half of your revenues derived from selling, your revenues derived from selling more than half of the California resident data that you have. So it's not going to apply to everyone. It's an interesting question that I get from clients when either they're on the line or they're not sure, or they don't comply, but they're thinking, well, do I want to comply anyway? there is a business decision here to make that isn't necessarily straightforward, and we'll talk about this a little bit later. A lot of states are thinking about or moving in the direction of incorporating a lot of concepts that the CCPA has. And so it's a legitimate question to think about, well, okay, maybe the CCPA doesn't apply to me. Does it make sense now to start investing in building out a CCPA compliance on the theory that it might apply to me in the future, or other states might reach me that have the same kind of effect as the CCPA? So it's something to think about. But nevertheless, just because you do business in California or just because you have personal information of California residents doesn't necessarily mean that the CCPA will apply to you.
Chris, if I can just make one note about the application here, and it relates to the revenue point. For me, it seemed, I don't know if you had a similar experience, but when we're talking to folks in 2019, everybody said, well, I don't have 25 million in revenues yet, but I think I'm going to have them in 2020. And my sense is now that folks who were on the cusp of that are now not going to have as good a year. And so I think it's something that people need to go back and think about. I wouldn't say, particularly if you've started your process, that you should halt, but it may determine where it falls amongst your various priorities. If you say, all right, we're going to take a real hit to revenue, we're not going to hit 25 million this year, something to think about. Maybe you go slower on the CCPA adoption than you might ordinarily. You can divert some resources knowing that, all right, we're not going to now hit that revenue target till 2021 or 22, presumably, that we're going to be down. Now, the other thing is you need to document that so that if somebody ever asks, you say, yeah, no, we were projecting that and we didn't make it and so forth. But I think it's a different scenario for a lot of companies in the current economic condition.
Colin, I think you make a great point, and I think that it's absolutely right to consider, well, I might not hit that target this year. Does that mean that I should divert my resources to places that might frankly matter more to my business? There's another, though, aspect of this that that organizations should think about, that even if you don't meet that threshold, this the 50,000 consumers or California residents issue is actually a really interesting one, because one of the things that isn't clear to me, at least in the law, is, well, does that mean, let's say I'm a retail business, or I keep a consumer database, and I have 100,000 consumers in that database, and 30,000 of them are California residents. What about all the California residents who go through my website, for whom I might be collecting cooking information or an IP address? In other words, that passive, the California residents who are all sort of passively going through my website, do they count? I think there's a good argument that they do. And so you need to think as well, okay, maybe I don't meet these other criteria, but there's this 50,000 resident criteria, and I don't necessarily have that number in my database, but I might have a bunch of California residents going through my website. So there are a lot of sort of there's some nuanced thinking here in terms of application that, especially if you're sort of on a knife's edge or you're not sure, it's important to take these considerations in mind. And also, it's important right now to think about these things because we really have no idea what the AG is going to do when it comes to enforcement. And I'd have to think that they're going to be a little overwhelmed with other kinds of issues come July 1st. And so they might not go after the organization with under $25 million in revenue in the first instance. But it is important to think very clearly through potential risks here, so that you can at the very least make a clear-eyed decision on what you want to do. And also, and Colin, you alluded to this point, maybe the plan is, okay, we're really not in a position to devote resources to full compliance this year, but we have a plan. Here's what we're going to do. Here's how we're going to do it. Having a plan for how you're going to meet compliance, where you're going to prioritize it, I think is really important, even if it means you have to put certain things on the shelf. It's really important, I think, to be at least thinking proactively about where this is going to fit in your overall plan, especially as other laws come down the pike. The last note I have here is regulations are nearly final, but still being updated. When Colin and I spoke to Mass TLC back in September, even the law wasn't final, At this point, the regulations are frustratingly still not final, but they've gone through 3 different iterations. And I think that it's fair to say that even though they're not final, we have a pretty good sense of what the law as a whole is going to look like at this point. And there are some important things to say. So before I move on, I just want to give some flavor of what kinds of things that the regulations do. They add various definitions, like what is employment information, and this matters because right now there's an exception for the application of certain CCPA rights to employee data. It's not entirely exempt, but you don't have to provide disclosure rights to employees, and you don't have to provide opt-out rights to employees. What's important about this is that while the regulations provide more clarity around these definitions, that exception to the law sunsets. It'll sunset in January 1st of next year. And we have no idea what the California legislature is going to do. If they're going to make it permanent, if they're going to give it another year, or if they're just going to let it sunset, and then all of a sudden employee data isn't going to be exempt. The CCPA also provides a very broad definition for personal information. It's basically, it's as broad, if not broader, than the GDPR's definition, which is basically everything, right? Your name, your IP address, cookies. The reason that it could be considered broader is because the CCPA has this funny inclusion of the word household. So both individuals and households. For the life of me, I can't understand how you can create household as a different category, but the regulations do flesh that out to explain what a household is and how that's different from simply an individual. The regulations also provide further clarity on issues like the privacy policy has to be accessible to individuals with disabilities. Well, what does that mean? They give industry standard information. As long as you follow certain industry standards, and you can be in compliance with that. It provides further clarity on when disclosures have to be made. I think that the best way to think about the CCPA is as a disclosure statute, and that way I think it's very distinct from the GDPR, which is lots of other things too, like a consent statute and a transfer statute, or set of regulations. The CCPA is fundamentally about disclosure and transparency. So the first thing that CCPA says is that consumers must be notified at or before the point of collection of what personal information is being collected from them and what's being done with it and who's being given to. The regulations provide more clarity around that. Provides more clarity around data broker obligations. Provides more clarity around what privacy policies have to contain. And then there's some complexity to the right to know. So individuals can ask for, what data do you have on me? But the CCPA is very, very concerned about fraudulent use of that right. So these requests have to be verified. And so the regulations provide some clarity about what it means to verify those requests. And there are other funny things that have been sort of added and taken away over the course of the drafting. So one is there was a provision on what does personal information really mean, and it essentially repeated the definition in the law. So that got taken out. And then there was this funny example of an opt-out button that was a little nonsensical and cartoonish that was added in the second version and then taken away in the third version. Not that it did any harm, but I think probably the AG realized it was they were getting a little derided. So just an overview of compliance obligations. I talked a little bit about this. You have to maintain a privacy policy that discloses rights. This frankly looks a lot different from what I would say the ordinary U.S. privacy policy for non-heavily regulated organizations looks like. So in your ordinary privacy policy, what you see is, what information do we have of you? We may collect an email or a name or IP address. What do we do with this? We use this to fulfill our services, and we might give it to others. You actually have to provide more detail in a policy that's CCPA compliant. Often, what we've done with clients is to actually create a chart that clearly lays this out. This question of readability is really important, and the kinds of obligations that are in privacy policies under the CCPA can end up looking very jumbled if you don't find a way to streamline it. So that's one way to do it, to sort of make it look more digestible for consumers. You also have to you have to let individuals know what their rights are, and you also have to have ways of responding to consumers' requests. So there has to be some outline in the privacy policy of how you're going to respond to requests, how long it's going to take, how you're going to communicate with people, whether you're going to seek an extension, that kind of information. But it's really this disclosure obligation. One of the important things that the regulations does is it says, well, okay, at or before the point of collection, what does that mean? Well, what it really means is what most organizations do now, which is you got to post a conspicuous link on your web pages, your front page and all of your other web pages. So as long as you have a link somewhere, that's going to be fine as long as it's conspicuous. What does that mean? I guess we're going to find out. A lot of organizations like to put it at the bottom so that you scroll down. There's no indication that that's not permissible. That might not be best practice. Best practice is probably going to be putting it somewhere right up front where it's always visible. But that's going to depend on what other kinds of decisions you need to make about what consumers see. There's an interesting part of the regulations that talk about what you do with a mobile on a mobile device where the privacy policy has to be. Interestingly, it can be hidden in a menu. It doesn't have to be right there on the screen. You can actually have it in a menu, in a menu, and that's enough for at or before the point of collection. There are certain liabilities. The Attorney General is the one with enforcement authority, and the Attorney General can provide civil penalties for violations. There's no general private right of action. This was an issue in the law, but there is one for relating to security breaches. So there's a limited private right of action. I'm just going to go over this briefly because I realize that we're almost halfway through here. So there are some similarities and differences with the CCPA and the GDPR. Here's what I'm going to say about this. I still get a lot of questions about, well, if I'm GDPR compliant, doesn't that mean I'm CCPA compliant? And the answer that I usually give is kinda. The part where you probably are going to be most of the way there is if you're already providing rights under the GDPR to be compliant, and you have devised a mechanism to do so. So usually that means mapping your data and creating interfaces for consumers to effectuate their rights. But there are differences. So the CCPA has this "do not sell my information." That's a little bit different than what the GDPR requires. The CCPA has this verified right to know. That's a little bit different than what the GDPR requires. So there are some differences, and it's distinct enough that that you do need to think a little bit about where the CCPA might diverge. But having said that, if you are GDPR compliant, you've already done a lot of the work to get you there with the CCPA. Colin, you want to take this one?
Yeah, Chris, before you go, one thing on the CCPA point. One of the interesting questions that's still outstanding is this determination about adequacy status. And as far as I know, the EU has not yet determined that CCPA is adequate for purposes of data transfer the way it has with some other jurisdictions like Israel and so forth. Any thought on when that might be forthcoming?
It's a good question. There have been some hints in the EU that at least it's under consideration. Number one, I can't imagine that that's going to. Well, if I were a regulator, I don't know that I would issue any kind of determination before you see what enforcement actually looks like. In other words, one question is, well, is it just paper? Is the AG actually going to enforce this or not? So I would expect that it would be after that. The EU process on this is actually surprisingly lengthy, and sometimes it can be fragmented. Now, it's obviously this is not a member state determination; it's a Commission determination, and so that means that it's not caught up in fragmented bureaucracies. It's caught up in one kind of lengthy bureaucracy. So I don't think it's going to be this year, but I've been wrong on these things before. The one thing I'll say about that, Colin, is that, and this is just my personal take on this, I can't imagine that they're going to do that. And the reason is, there are plenty of organizations that are going to look at the CCPA and say, okay, I'm gonna split up my customers or my the population of people I'm collecting from. Some of them are going to get the CCPA rights, and some of them are not. And so it strikes me as probably really complex. And plus, the CCPA doesn't provide anything with regard to transfer outside of California. So it seems like it seems unlikely.
Okay. All right. Thank you. So on to CCPA and HIPAA. I think everybody knows what HIPAA is. HIPAA has come to the forefront lately, and this is the part of the presentation where we start talking more about COVID-19. Obviously, everybody's a little more interested in medicine and medical information right now, and there is health information flying around because we need to get that information in order to get on top of things in terms of diagnosing the virus, tracking people who have the virus, who may have had the virus, who you've come in contact with. All of this is now incredibly relevant. And so how CCPA interacts with that is also incredibly relevant, and where HIPAA falls and all that. So the good news is if you've got HIPAA covered information, which is called PHI, when it's transmitted by a HIPAA covered entity, then you've got an exemption. So that's the good news. The bad news is if you're not one of this narrow group of entities like a healthcare provider or a health insurer who fall within those definitions, and you've got health type information, which now almost everybody has in some way, shape, or form, if you're employing people, then you've got to deal with CCPA. An example that comes to mind. So let's, as we think about return to work policies, what's going to happen in your workplace? Well, I suspect that people are going to get, portable thermometers. This is a stapler, not a portable thermometer, but they're going to go like this to your forehead with the portable thermometer and take your temperature when you come on in the building. Okay, guess what? You've now just had an event that qualifies for CCPA if you fall under CCPA, if this is in California. It's going to have similar ramifications under a lot of other state laws, but you've got to think about you're collecting that. Now, as Chris correctly said, employment information is currently exempted from CCPA, but it's on a 1-year window. And so I think there's going to be a lot of discussion about, gee, doesn't this information really need CCPA protection? So as you're gathering that information right now, you've got to think about, okay, how are we going to do this in a way that if it turns out that we don't have the employee protection of that carve out anymore, how are we going to protect it? You've got to think about that right now. And obviously, any kind of electronic network activity, cookies, things like that. So everything that's being talked about in terms of contact tracing is not exempted from CCPA. Those are things that don't fall under HIPAA by and large, because they're going to be done by individuals who are not working for or part of healthcare providers. It's a public health function, and that doesn't fall within HIPAA. Maybe it should. Maybe it will get an amendment at some point. There's a lot of people saying HIPAA is outdated, but right now it doesn't. And so you're going to have to deal with the CCPA regime on that. There's a lot of other information out there that you need to think about. We've got a lot of labs that are doing testing. A lot of labs actually are not HIPAA covered entities. We're working with a number of labs right now that formerly did things that weren't under HIPAA, and now they're transitioning to do COVID testing, but they're still not HIPAA covered entities. Similarly, you've got medical device manufacturers who may not be covered entities, but they're collecting lots of information. So all these things are things to think about now in the new environment where you're not going to have a carve out, and you've got to think about how CCPA is going to apply to that information.
And I'll just jump in really quickly, Colin, and give the baton back to you. Just the last point on CCPA is that in a way similar to HIPAA, there's a carve out as well for the Gramm-Leach-Bliley Act. So that's financial institutions that are covered by the GLBA. I think the best way to think about this is that the CCPA begins where the GLBA ends. So anything that's not GLBA covered is going to be covered by the CCPA. So anything that's not, essentially non-public personal financial information is going to be covered. I just think it's important because the CCPA, I think, is unique in this respect, both with HIPAA and with GLBA. What you see in a lot of state privacy laws is blanket exemptions that if you are compliant with, if you're a HIPAA covered entity or you're a GLBA covered entity, as long as you're compliant with that respective law, you don't need, you're going to be deemed compliant with this law. And that's really not how the CCPA works.
No, it's not. So now we get to the fun stuff, the compliance questions. So, and this is where it's really challenging for folks who are trying to comply, because there isn't this consistency that you would hope and expect for. And there's no sign at all that we're going to be getting universal federal legislation. I mean, right now Congress can't even meet. So the odds of us getting legislation on anything that's not COVID related are pretty slim. So we've talked a little bit about the California Attorney General's office and what they're saying. They're saying, nope, we're not slowing down. And if anything, I think what we've seen from their pronouncements is a doubling down. They're saying that COVID proves we need the CCPA, and I take them using this as an opportunity to prove the worth of CCPA at this time, which isn't so great. But if you look at their website, there's a lot of emphasis on the rights of consumers at this time. So they're not relenting. Contrast that with the Office for Civil Rights, the Department of Health and Human Services. They have relaxed just about every regulation that you can relax. They've said, basically, you want to use Zoom for telehealth, go right ahead, do it. We just need to deal with COVID-19, and we'll pick this up later. Now, of course, it's not a free pass. What I've been encouraging folks to do is do the best you can in terms of compliance. And I think that holds true in any of these regimes, to think about, well, all right, I may not be able to be perfect, but document that you're doing the best you can, document why you could do that extra thing. Essentially, good answer is we're in a pandemic. And there are things actually you can look at. In particular, if you are providing specific relief to individuals in connection with the pandemic, there may be the applicability of a thing called the PrEP Act, which can provide you with at least federal immunity for torts that are committed. So something to think about in all of this if you wind up committing a tort somewhere in here, hopefully not. Then we go back to the Federal Trade Commission and think about what they're doing. They've taken a view that's more like the California Attorney General's office. They've been very active in thinking about how there are potential fraud issues, which are coming up a lot. You see fraudulent schemes related to this. We see a lot of information security issues with the possibility of funds being intercepted, as there's essentially trillions of dollars flying around. The FTC, it's got a role there. You look at and then you say under GDPR, what's the EU said? The EU said, well, we can send information to the US because they need it, and there are some public health exceptions under GDPR. So I think if you look at it, it's interesting how California stands out in the message they're sending here, which is we are not pulling back at all. Now, Chris raises this, it's a legitimate question. What kind of resources are they actually going to have? I know that I've seen it in our own Massachusetts State Attorney General's office, that I've tried to schedule meetings with certain people and they said they're not available. They're working on COVID stuff, which is totally understandable. So I think it's going to be an interesting question to see what resources the California Attorney General actually has available for non-COVID CCPA enforcement. I think the answer is maybe not much.
Can I
go ahead.
Really quickly, and I just find it interesting if I can just focus on the EU member states for a moment. I do find this is one of the things that I find personally, well, I want to pull my hair out sometimes, because the one of the issues with the GDPR from my perspective, and I suppose I could think about this the same way in the U.S. with all of the individual states, but with the GDPR, every member state is its own enforcement authority, and so what that means is that every member state that thinks about it can issue its own guidance, and so what you have is a EU Data Protection Board issuing a guidance on how we're going to treat COVID-19 or privacy during COVID-19 or compliance during COVID-19, and then Germany is, and then the UK is, and then Ireland is. And while, Colin, to your point, while a lot of it lines up, there are enough differences that it's really hard to say, you know, how is this gonna be treated if there's a compliance issue, you know, over the next couple of months. So it can be a little frustrating for stateside companies that are already thinking what their GDPR compliance is, to figure out, well, what's going to happen if I'm non-compliant and I've got, you know, people all over the EU that have personal information. So I just wanted to interject that.
Yeah, no, absolutely. And it's, you know, the flip side of that is what we usually see in new regulatory regimes is some set of consensus emerge of regulatory best practices among industry. And you start to see it. And we would see it, say, you know, and clients will say, you know, what are you seeing? And we say, okay, here now is what is, you know, sometimes you call it what's market. This is what people are doing. And I haven't seen that at all under CCPA. You know, all you have to do is, you know, you look at websites, and everybody's website's different. There's no uniformity there in terms of how they've responded. It's all over the map. And I think that that's partially a reflection of the failure of the California Attorney General's office to get out in front of this in terms of its regulations. The fact that the regulations are still not final means there's all this uncertainty. So I blame them. If they're listening, they've heard it from me now. A little early in California, I suspect they're probably not awake, so I'm safe saying this. But they really need to get these regs final because the uncertainty is not healthy for anybody, and it doesn't serve their goal here. In the meantime, in the face of all this uncertainty, you know, you've got to try to do the best you can to continue with compliance, but it may be realistically, let's say you've had a layoff. Okay, we had somebody who was the privacy officer. That person is now on furlough or they're working from home, and our compliance efforts on CCPA have stopped because we're trying to think about getting people back in the office, or we're still struggling with remote. To me, I understand that, and I think the California Attorney General's office is ultimately going to have to understand that. But again, document what it is, what's happened, if you were in the midst of something. So if you have to go back, you have records that show, hey, we were on the track, on our way there, and then something else happened. I think, you know, to have that kind of documentation, even if it doesn't get you out of hot water entirely, it's an ability to try to reduce a potential penalty by saying, hey, there's a good reason why this happened. Now, one of the things you can do now, and that we've frankly been doing with lots of clients, is training folks remotely. Even pre-pandemic, where we were working with clients who were distant, we got on technology like this, and we trained folks, and we recorded the training so they could play it back. And you know, that's an efficient way to do it in any context, and you can still do it now. So there's no reason to say, oh, you know, we don't have the ability to get people all in a room together. You may not have that ability for months and months and months. So don't put off the training, but just think about different modalities in which you can do this to try to make sure you're improving the level of understanding of the obligations that we've got. So that sort of blends into some of the new issues that are coming up and that, you know, we're already seeing. So you've got remote workers. You've got to think about them in the context of CCPA and all the other things that apply. We've talked about Zoom. Everybody knows about Zoom bombing. These are things that are relatively easy to fix from that standpoint, but there are other layers to this in terms of the way information is stored. Talked about recording. Things can be recorded. You want to make sure you're on top of that. I talked about the increase in some funds interceptions. We've got ransomwares going through the roof for healthcare institutions. Cyber attacks, I think I saw a statistic yesterday, are up 30,000% or some crazy number like that. It's just through the roof. So, and probably most of the folks on this particular call know that. So it's nothing new there. And there'll be some level of understanding and enforcement. But I think it's important as we're going through these steps to think about where there are new places where you're going to have potential for leakage in your envelope of your business, because the envelope is now much bigger. Talked about some of these new privacy concerns in testing and tracing and surveillance. All of us are going to have to deal with that. And, you know, I think it's an important thing. You know, I was just listening on the radio today. Google and Apple have come out with their new tracing tool. And the question that a privacy advocate raised was, well, I hope when more of a statement, I hope when the pandemic's over, they delete the data. First, I laughed because I said, there's no way they're deleting that data. Not going to happen. But you have to think, okay, you're going to keep the data, but it can be de-identified at that point. You know, if you're not actively tracing somebody, I would never suggest to somebody that's an incredibly valuable data set, but it can be de-identified. Similarly for your employees. At some point, some of this data can be deleted, and you're going to have to think about that in terms of what your obligations are to keep the information, what your obligations are not to keep the information, and that's going to be tricky as we work through this time. And these are, you know, talking about, you know, industry consensus and best practice. There's certainly none of that going on right now.
So I'll briefly.
Yeah, go ahead, Chris.
Yeah, I was going to say I'll very briefly talk about other state law changes, because we spent a lot of time talking about the CCPA, but it's worth reminding everybody that there are 50 states and there's a lot of activity. So for anybody that has the information of New York residents, the New York SHIELD Act has essentially come into full effect as of last month. And it does a couple of things. One is it's not as broad as the CCPA. That's the first thing. So it doesn't provide the same kind of rights. But there are a couple of things that it does that I think are very important. The first is that it broadens the definition of personal information for purposes of data breach notification. It also broadens the definition of a data breach. It used to just be acquisition. Now it's access and acquisition. So that's almost everything that's beyond an incident that's actually a breach. It's expanded that definition. It's also done, and to my mind, this is actually the most important thing that it's done. It's actually created a written information security program requirement. So it has created specific security obligations that are sort of on a sliding scale depending on the size of the organization. But it really does require, in less detail than the Massachusetts regulations require, that organizations have a way of documenting their reasonable security practices. I think following the Massachusetts regulations is a very good way of doing this, and that would include vetting your vendors, security, training your employees, and making sure that you have fairly industry standard ways of protecting data, including encryption, firewalls, the standard sort of cyber hygiene stuff that I think folks on the phone know technically better than I do. But it's a very, very important law, and I think primarily for that reason. There is a lot of proposed legislation around the country, including Massachusetts. They're at various stages. In Washington, a second attempt at a CCPA-like law just was defeated, although they did pass a biometric related law. California's got CCPA 2.0 coming up, and that's going to be, so Colin, you asked me before about the adequacy determinations for the CCPA. The CCPA 2.0 proposed legislation is robust enough that I might change my answer if that actually becomes law. And that includes definitions for sensitive information. It creates a specific privacy agency, enforcement agency. It does a lot of things that would make an already robust U.S. law, it could be close to a global standard like the GDPR. So, but we'll have to wait and see, and that wouldn't come into effect. The earliest would be 2023. There's also increasing concerns about biometrics and artificial intelligence. Illinois passed a recent law on the use of AI in employee interviews and hiring decisions. I think that that's only going to increase, and they're going to be tied. You're going to see. I think you're going to see a lot more over the coming years. Comprehensive privacy laws that tie in these different concepts of automatic decision making by AI and the use of biometrics. And by the way, I agree with Colin. By the way, just one thing you said I was going to say, so you stole my thunder. Even though there are, I think there are like a dozen different federal bills, I still don't think we're going to see a federal law in my lifetime. Certainly not during this time.
Well, I think we'll see it in well, I'm planning to live a long time, current circumstances set aside, and I think we will, because I think it's going to come up to the point where people are realizing it's impinging on commerce, but we've got to get past, it's not going to be 2020. That's for sure. But 2021, 22, I can totally see it. Absolutely. And I think, one of the things you talk about AI, one of the things that's going to start to, we're thinking about how things are going to change. What's going to change? The person-to-person, in-person interview. We're going to be interviewing people a lot more this way. And we're also going to be screening people with AI. So you've got to think about those things and how they are impacted by CCPA and these other state laws.
Yeah, I think it's a great point. There are real world impacts here. I do want to for questions. So a lot of what you have listed here now is what you expect any to say at any point, which is just as important about your policies and your auditing and your breach response now as it has been. And if you want to say anything about the opportunities for fresh thinking now.
Yeah, I mean, it is, the saying is, a crisis is too important to waste. And I think this brings up ideas. The way we work, frankly, is changing fundamentally, and that creates opportunities. It also creates risks. But I think we're all looking at different ways to work, and that means that information about how we work and the information we generate when we work is going to change. And that has implications for CCPA and every other state law and every other federal law and the GDPR.
All right. So we're happy to open it up to questions. We've got about 12 minutes left. I haven't seen anything asked, but if folks have questions now, we're happy to entertain them.
Yes, and this is Sarah chiming in. Please use the chat. You could use your questions. You could raise your hand. I can unmute you so that you can introduce yourself and ask a question. I'm monitoring everything now. I don't know if people are typing. As people think about their questions and type them in, what do you think in terms of CCPA or GDPR, because as we know, this is a global pandemic, will cause them to start to think outside of this emergent situation that we're in and think about ways in which things need to be improved? Do you think it will be during the enforcement and companies having to potentially fight, that they haven't done something wrong or that there was no way around it? Do you think it will be, something that happens in the courts, or do you think legislatively people will think ahead to think around some of these, temperature taking and biometric data and, companies, as you say, contact tracing, all of these things are going to be happening, and companies are going to be, we do these calls with CEOs. Almost all of them are going to be implementing something along those lines for reentry. And on top of that, it's not just necessarily their employers. So what happens when the delivery person comes in, or any of those things?
Yeah. No, I think we're going to be led for the near term by business developing the policies that will demonstrate what the consensus is on what's appropriate, and only in the event there's some outliers. I mean, I know I've been advising folks already who want to be taking temperatures, they want to test their employees. And, you know, I've got clients, I got a client with 14,000 employees. They want to start testing each and every one of their employees. This is going to go on over and over the place, all over the place. I've got other clients who develop the COVID-19 tests, and they're selling them to large, really, really large employers. So this could become an employer-based testing scheme. And sort of think of it, what else do we have in healthcare that's employer-based? Well, your health insurance. Your employer has a lot of information on you from health insurance, but that's siloed. And indeed, that's mostly covered by HIPAA. This isn't. And so we've got to think about new ways in which it's processed. You know, your health information typically stays with the HR folks who process your benefits. That's the way it should. But who's the internal mechanism for processing the information about whether or not you had a COVID-19 test and whether you came up positive, and you know your serological test and whether you've got antibodies? Are you still shedding virus? Do we know that? What's your temperature? What about your family? All that stuff. Nobody's figured out how to deal with that in any context, let alone under the CCPA. And so we're going to have to figure out ways to deal with that massive amount of information. You know, talking of 200,000 to 300,000 contact tracers in this country, probably by the end of the summer. They're going to generate a lot of information, and we have no idea how we're going to manage that. So that'll be fun.
I think so. You're exactly right. I have an additional thought, and that is, some states have general privacy, right to privacy laws, right? So a lot of compliance issues that we deal with have to do with either industry-specific laws like HIPAA or GLBA, data breach notification statutes, CCPA compliance, that sort of thing, sort of day-to-day stuff. But overlay that could become depending on what businesses actually do and how governments and individuals respond. So Massachusetts, for example, just has a statutory general right to privacy, and it'll be interesting to see if, you know, depending on whatever the test and trace regime ends up being in Massachusetts, for example, you know, will individuals try to test that regime through that statutory mechanism? Because that to me seems like an obvious mechanism. It allows for injunctions, it allows for damages. It's broad enough that it can be used here by employees. I mean, part of it too is, you know, you look at a lot of the case law under statutes like that, and a lot of it looks like language that you'd see under the Fourth Amendment, which is, well, do employees have a reasonable right to privacy, and what does that mean? And the question is, what's reasonable under this circumstance? So I do wonder whether you're going to see some of that being tested under those broad mechanisms.
Mm-hmm. So and Chris, that sort of brings up a question that I know people may be wondering is, you know, we've talked about government enforcement, but at some point under CCPA or any of these other statutes, are we going to see consumer actions, consumer class actions? I think there's been a little bit of activity under this in California, but not a lot yet, right?
Yeah, so there have definitely been in California since January 1st. There have been consumers who have added CCPA theories to class actions. It's almost never standalone, at least as far as I've seen. It's usually alongside other claims, which is frankly smart as a litigator, because you have no idea how courts are going to interpret CCPA, and frankly, it's so narrow what private actors can do that it remains to be seen what courts are going to do. But you're right, consumers have absolutely been testing or been including CCPA claims.
Yeah, and I think again we'll see more of that. That may actually be something that leads the way in the development of the law in California, which may not be a good thing, but you know, in the absence of clear guidance from the California Attorney General, somebody's going to have to sort out what this means. And I think, you know, the plaintiff's bar is always willing to push those boundaries.
Yeah. Yeah. Well, yes, because they rarely actually go to trial. They usually settle.
That's right.
They don't get dismissed.
All right.
So I am not seeing any questions or anything in the chat, and we are winding down. So Chris, Colin, thank you so very much for everybody on this webinar today. We have recorded this, so we'll make this available on MassTLC's site, and we will send a link out to all of you with a summary. I want to thank you all for coming this morning, regardless of what is going on, or maybe even more so because what is going on, these regulations are more important to understand than ever. I also just want to very quickly thank Foley Hoag for always supporting us, for Deloitte, and to our global sponsors. So thank you. Enjoy the rest of your day, everybody.
Thank you.
Thanks,
Bye-bye.
everyone.